The Personal Information Protection and Electronic Documents Act, also known as PIPEDA, or however else you like to say it, is a comprehensive Canadian privacy law which protects personal information in private sector commercial transactions across Canada, as well as in employment in the federally regulated private sector like banks, air and rail transport, and telecommunications. PIPEDA does not apply to interactions with governments, it doesn't apply to provincially regulated employment, and it doesn't apply to commercial transactions in BC, Alberta, or Quebec, because each of those provinces has its own privacy law which takes precedence over PIPEDA. Among other things, PIPEDA sets out principles and rules for collecting, using, disclosing, and storing personal information. Those principles are accountability, which means that organizations are required to be accountable for how they handle personal information and protect privacy. Identifying purposes, which means that organizations must know in advance why they're collecting personal information and then must tell individuals what those purposes are. Consent, which means that organizations must have the consent of the individual to handle their personal information, except in certain specified circumstances. Limiting collection means that organizations can only collect the personal information they need for the purpose that they set out. Limiting use, disclosure, and retention means that organizations can only use and disclose the personal information they collect to the extent needed for the purposes and not more, and can only retain personal information for the time period needed to achieve those purposes. Accuracy means that organizations have to take reasonable steps to ensure personal information that they use is accurate. Safeguards, it means that personal information must be kept safe and secure to avoid unintended or unauthorized access, disclosure, or loss. So that's usually what people refer to as information security. Openness means that organizations have to make public statements about how they handle personal information and answer questions from the public about those practices. Individual access means that individuals have a right to access their personal information except in certain specified circumstances. And the final principle under PIPEDA is challenging compliance, which means that individuals have the right to question whether an organization is compliant with the law, and they can make complaints both to the organization and to the Privacy Commissioner. PIPEDA applies to background screening companies like Sterling Backcheck because background screening is a commercial service. It also applies to users of background checks like employers when they are subject to federal regulation. The laws in Alberta, Quebec, and BC are similar to PIPEDA and apply to provincially regulated employers as well. So many employers across Canada are subject to privacy laws when they use background screening services. Some of the key PIPEDA principles which concretely apply to background screening are the identifying purposes and openness principles, which mean that individuals need to be told what background screening is going to be done and for what purposes before it starts. The limiting collection, use, and disclosure and retention principles mean that only the data that's needed for the screening should be collected, and it should only be used for the screening, not for another purpose. Only disclosed to parties that need it for the purposes of the screening. And finally, when data is collected for background screening, those records should only be retained as long as needed to meet business needs and comply with legal obligations. The accuracy and individual access principles are also important in background screening. These mean that background check information needs to be correct to be used for decision making, and that individuals need to be able to get a copy of the information that was used to make a decision and challenge its accuracy and have it corrected if it's wrong. Consent is interesting because not all employers actually need to get consent under PIPEDA and provincial privacy laws, because if the information is necessary for the employer to establish, manage, or terminate the employment relationship, then the collection is really mandatory. The individual doesn't have a choice, and so consent isn't really real. That being said, candidates always need to authorize the background check to allow third parties to release data and to allow background screening companies to prepare reports. So in effect, individuals are giving consent for background checks.